only have a short time for class tonight because Justice Hines is coming. First African-American woman to be on our Supreme Judicial Court. And actually, the other interesting thing about that at this point means that our Supreme Court is dominated now by females, and there are too many in the country that if any. I thought someone said that ours was the first. I don't know whether that in fact is true. So, but we're on, I think it's section 6, but it starts with Franks versus GMC Truck Center. And we're getting close to the break. We've got a couple of weeks till we get to the break, so we've got to, you should start being ready. For those of you that are going to take the midterm, preparing and reviewing and getting ready for that. And those that aren't should be looking at the questions to make sure all the questions are submitted. Then by the time spring break is over, and we said that they'd do the Monday following spring break. Did I give you time? Huh?
By midnight.
Did I say that midnight on that Monday, right? Okay, that's right. That sounds like something I'd say. So we're on Franks versus GMC Truck Center. We've got a few cases that actually look specifically at how injunctions work. We also have motions to dismiss, which we'll talk about on Thursday under Rule 12, and they're important to understand as well. So you ought to take a look at Rule 12 so that when we do talk about it, you'll have some understanding. Someone was taking the bar exam. Someone is taking the bar exam tomorrow. They had a question. They wanted to know what how the bonds work again, and that's the section with respect to injunctive relief. And it's something we don't talk about when we usually look at Civ Pro, but it becomes something important in practice because you're supposed to, if you look at Rule 65, in order to obtain injunctive relief, you are supposed to provide a bond of some sort prior to the issuance of the injunction. And that bond, as we're going to see, and we'll look at it a little more clearly in the cases, that bond is supposed to be available to the enjoined party in the event that the injunction is later determined to be improvidently granted, that the court was in error in granting it. That bond is supposed to be there to compensate the enjoined party for any damages they suffer if it's later determined that that injunction never should have issued. So this bond becomes an important part of granting injunctive relief, but it also becomes another tool from the standpoint of the party who is being enjoined to add another level of argument to their case by suggesting that the bond should be sufficiently high and that the defendant will, in fact, incur such additional expenses that the bond has to be high. And there will be cases then where you won't be able to obtain the bond because you may have to put up a high level of surety in order to get it. So I want you to start to think a little more about the bond because Rule 65 requires it, and we're going to see what the cases actually talk about as to how that bond is supposed to work and the like in practice. So we're looking at Franks versus GMC Truck Center, and it says, following removal from state court, the United States District Court, the District of New Jersey, enjoined truck manufacturer, blah, 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 blah. How does something go from state court to federal court? Because that's what it says happened here. How's that work? Go ahead.
If it could have been brought in federal court in the first place, either based on diversity jurisdiction or a federal question with concurrent jurisdiction, then the defendant may remove it to federal court. Did I miss one?
Huh? Oh, right. Oh, I see what you said. Why you said concurrent. Right. A federal question that, as it turned out, had the ability to go to state court. Because I was just going to say, in part to correct you, but I think now I've got a better handle on it. Every federal question can go to federal court. It's only some that can go to state court. So what you're saying is the argument is that it was a state court matter that, a federal court matter, federal question that because of concurrent jurisdiction go to state court, it can be removed to federal court. So the defendant has the right to remove an action from state court to federal court if it could have otherwise been brought there in the first instance. Right? That's in essence what you said. Is that the complete rule? on removal jurisdiction? It's close. Nick, you think, Nick, with some real trepidation, you got a little more to that rule, Nick?
If it's a case involving a constitutional matter, a federal question on point, federal statutes, things of that nature, it can be moved to the federal court to be decided.
And
Oh, God.
if
Gave it
it's...
all I got, Captain.
Huh?
I gave it all I got.
And if it's based on diversity, what's the rest of the deal on that?
No,
No plaintiff or defendant can be from the same state and it has to be $75,000 or more.
Okay, and for removal?
it can't be removed to a federal court in the state that the defendant is from?
That's close enough, I'm going to give it to you. The defendant doesn't have a right. If removal is predicated on diversity, and it's entered in the defendant's home state, the defendant does not have a right to remove from state court to federal court. Because the argument being that there is no local prejudice to that defendant since they are an in-state defendant. So removal's automatic if you request it on a federal question or a constitutional issue. The only requirement on a diversity question is that if it's removed on the basis of diversity, in order to do so, the defendant cannot be from the forum that the case was filed in. Otherwise, there's no removal jurisdiction even on diversity under those circumstances. You have to understand this process and how it works, because there are a lot of cases you may enter are going to end up potentially removed in federal court. The plaintiff gets the first move, not necessarily the last move. And a lot of times defendants, especially large defendants like General Motors, as you see in this case, prefer to be in federal court. I'm not sure there's the big difference that some of them see, but because they favor it so much, you do have to pay heed to that a lot of times the concern is that the federal court favors those types of defendants. Frankly, from a standpoint of practice, as I've said to you before, it's really nice in federal court. I mean, it's not that crowded, it's not that busy, the cases get heard relatively along the times they're supposed to. It's a beautiful building. It's a nice level of practice. And what I particularly like about it, as I think I've said to you, is that when it's assigned to a judge, that's the judge I get for the rest of the case. And it's nice not to have to be re-educating a judge or wondering down the road who I'm going to get for trial, and I have to sort of change my analysis about settlement and the like, depending on who I ultimately think I might get that case before. In a superior court in Massachusetts, those judges change with some regularity. It's not the way it works in federal court, but the large defendants tend to favor federal court. And again, the other part of the problem, just if you want to think about the chess match, not just the first move, is sometimes they're moving it to federal court as the first move, not the last one. Then they're going to try and transfer it to an area outside this region on a forum nonconvenience argument for trial, and that significantly increases your costs and expense, and maybe, frankly, means that you're not going to be pulling the sled anymore, but you're going to be second chair or maybe even third chair if that case is transferred to Philadelphia or California or God knows where. So that can become really problematic, not just from the standpoint of costs and expenses and inconvenience. It could mean a significant reduction in your fees as well. But at any rate, they filed in state superior court in New Jersey. Well, let me ask you that. You read the case. So Frank's is the people that filed. Frank's GMC Truck Center somewhere in New Jersey files it. Do you think they felt they might have had an advantage in superior court of New Jersey, where they're a local party with local potential people being employed there? And General Motors from big old Detroit said, I don't think we're going to get necessarily a fair shake here in some podunk superior court in New Jersey. Let's see if federal court might be a little more to our liking. And I think that probably was part of the dynamic here. They each thought they had a better place to be. But at the end of the day, the plaintiff gets the first move, not the last move, and the defendant could remove this from state court to federal court. And what was removal predicated on here? Because it's really not a federal question, is it? Does this involve federal statute? Does this involve a constitutional issue? What did allow them to remove from state court to federal court, do you think?
Diversity.
Yeah, I think it's diversity, because it appears to be just a straight contract action, right? Doesn't really appear to be involving anything more than that. And as long as the plaintiff and defendant are not domiciled in the same state, and that the claim is reasonably likely to exceed $75,000, they have the ability to remove it, and that's precisely what they did. Not unusual at all that a defendant like the size of GM would want it out of state court and in federal court. So what does Franks want? What do they want the court to order here by way of the preliminary injunction? What does GM want to do? What does Franks want to do? What's the problem here anyway?
Doesn't Frank want to prevent GM from terminating its supply of those new heavy-duty trucks?
So they want them to continue to supply trucks and parts
And parts, yeah.
and honor the warranty requirements. And why doesn't GM want to do this anymore? Why don't they want to continue to give Frank's GMC trucks so that Frank can sell its trucks?
They merged with Volvo?
Yeah, they want to get out of the business, it seems, right? I mean, they just don't want to be involved with having to do this business anymore. We don't want to supply the parts. And I think, as Andy said, we've turned it all, in essence, turned it all over to Volvo, wasn't it? Obviously, you would think that they're doing it because they don't see it as sufficiently profitable, and they can make more money if Volvo does it somehow, or Volvo pays us to do it, but they really want out. And so Franks goes to court because it said that they had a long, since 1937, right? Franks has been a GM franchisee since 37. Sold its full line of trucks since 73. October 86, GM informed Franks that it had formed a joint venture with Volvo, in which GM was to be a minority participant to manufacture and market heavy-duty trucks. It was no longer going to manufacture and supply them with heavy-duty trucks and parts. They're out. In essence, is what they want to do. Franks doesn't want them out. They're making money. Franks wants, and does, in fact, go to court and gets, right? Doesn't this?
Yep. Interim action.
The Superior Court of New Jersey, and in addition to money damages on injunctive relief preventing GM from discontinuing its supply of heavy-duty trucks to GMC, and wanting that continue to get parts and warranty business as well. And the district court, in fact, granted an order to that effect. Denied Frank's request for an injunctive, preventing them from terminating it, but they did give, from supplying new trucks to them, but they did give them a temporary relief in saying you've got to continue to give them parts and supply the warranty administration for the trucks during the outcome of the litigation. And GM obviously doesn't even want to do that because they're saying, well, I don't know where their damage is, but we're going to have significant damage if this is what you make us do. It's going to be an expensive process, and we shouldn't have to partake in a business we no longer want to be involved in. First point I want you to think about is what's in Roman numeral 2 here. It says, we have consistently held that our review of the grant of denial of preliminary injunctions is limited to determining whether there has been an abuse of discretion, an error of law, or a clear mistake in the consideration of proof. You know, a lot of times a client's going to ask you, well, can we appeal? What if we appeal? What are our chances? And you guys have to be able to then know what the standard of review will be on appeal, meaning if the court's going to look at this, what standard do they use in deciding whether they can reverse it or not? I taught a bunch of you evidence. The similar rule issue comes into play with respect to injunctive relief. It's even broader, actually. But the court is going to give a fair amount of discretion to the trial court. The trial court has to make decisions relatively quickly. And requests for preliminary injunction go even further, that while there's time for thought and deliberation and the like, we still have historical equitable principles which says there's a huge amount of discretion at play here as long as the court applies the appropriate test, which we've talked about, the 5-part test. And so here what they're saying is there has to be an abuse of discretion, in error of law, really misuse of the law, or applying, wrong law used, or right law applied improperly, or a clear mistake in the consideration of proof, not something reasonable people could disagree with. And so in order to reverse this finding, they're going to have to find that there's a clear abuse of discretion, which that's going to be a pretty high standard. But despite setting it as a relatively high standard, the court focuses in relatively quickly on the issue of irreparable injury. And let me ask you that. How is Frank's going to be irreparably injured if GM no longer does this? Because most of this would appear to be about economic injury, isn't it? It's money. And if really what you have, and this is what we look at in a lot of injunctive relief cases, is really what you have, a money damage case, well, we can give you money. At the end of the day, we'll have to sort through the damages, figure it out, but we'll give you money, and we can move on. And if there's an adequate remedy at law, if money damages will make Frank whole, he not only loses on the first one, that he's got an adequate remedy at law, but it's not irreparable if money will make it right. And so that's what the court focuses in on relatively quickly, is this a purely economic injury? If it is, it's compensable in money. It is, isn't it? I mean, is there something else Frank is losing here? He's had the dealership since '37. He's had the truck part of it since '73. What about that? It's sort of a goodwill. Our lifelong dream was to own a GM dealer. That's what we're doing. That's still money?
It's money.
It's money.
I don't know. I feel there's more to it. It's his livelihood. Maybe he wanted to have this company and pass it down to his kids later on.
He might have.
I mean, and that they're just literally cutting his legs off from under him. He can't do that. And it's something he's been doing for the rest of life. He's done for his entire life, and now he's suddenly has to stop doing it.
But they would have the right to terminate the contract, right? I mean, it's not like the contract says we will provide all this for life or forever or for the next 30 years. GM has made a business decision to get out. If you say you're suffering economic loss as a result of it, pony up the losses, and if GM owes, they'll pay. But that doesn't give you the right to injunctive relief. The problem with this, and that's why I think you really got to think about it and look at it, though, is that there's an awful lot of cases where if this is the logic, that what does immediate irreparable injury mean? If that at the end of the day, all we got to do is sort of factor what the number actually is and write a check for that, or theoretically write a check, then you're up. And that is what they're saying, is that you're gonna actually have trouble on two fronts of the 5-part test. I don't think you're going to get past no adequate remedy at law, but the court also is saying here it also undercuts any argument about an irreparable injury, because it appears you're saying money can repair it. Frank won at the district court, at least on part of this. They did not then require the bond. So tell me what that bond is for, and if you're General Motors, what your argument is as to how much that bond should be. What's the bond for in the first place? So Franks wants the bond, wants injunctive relief. Court says, at least GM says correctly, and the appeals court is saying, there should have been a bond. What's the bond? What should that bond be for? Why do you have to post a bond anyway?
Well, wouldn't it cover any and all damages that resulted from wrongfully granting an injunction?
So who would the damages be to in this case?
It would be to GM.
Okay, and what, in essence, would you say would go into that? Because this would be your argument in trying to oppose injunctive relief, is that, okay, if I'm gonna lose, then I want a pretty substantial injunction bond. So what would it be? Why are you saying there needs to be a bond at all? Well, the rule says it does. But what should go into computing what that bond is?
The evidence you got to show the highest amount of value that you want?
What's that mean? Like, what, in concrete terms, what would you be arguing? Go ahead.
What kind of money are you going to lose as a result of this injunction?
So like, but what does that mean in concrete terms to GM here? Like, what would you say those items would be here?
Your normal amounts that you would annually get for just the truck sales or your part sales or?
Well, but I thought you farmed that out. So what is the additional expense that this injunction is going to require you to do that you say you need the bond for? What is it that Franks wants them to do?
Continue supplying the parts and honor the warranty.
Okay, is that going to cost GM money?
Yes.
To continue to supply parts and to continue to somehow administer the warranty service, right? If you're GM, you should be arguing, A is going to cost me X, B is going to cost me Y plus Z plus X. We're looking at, it would seem to me, just trying to think about this, we're trying to get out of these lines of business to require me to continue to either manufacture, obtain parts and ship them to you, and also process warranty claims and pay those claims. I don't know how many hundreds of thousands of dollars we could be talking about, but I think I shouldn't have to do it at all. If I have to do it, I think the appeals court down the road is likely to say this was a mistake. I want a bond of $200,000, $300,000. Is it $500,000? I don't know. But what I know is if I'm GM, the higher I make and the higher you make that argument on the bond, the less likelihood that the plaintiff is going to be able to obtain the bond and be able to get injunctive relief, because if you can't post the bond, you can't get the injunction. And that's what GM is arguing here, is there should have been, at the minimum for this, there should have been a bond filed, and the bond, depending on your argument, should have been significant, because actually that argument, by the way, is in footnote 7, right? The record reflects that if Frank's GMC does not prevail, as it is not, GM will have been damaged. 1, by any difference in the amount it received from Frank's as payment for the parts it must provide to Frank's and the amount it pays to obtain the parts. 2, by the amount it will spend to set up and administer the warranty service program, as well as the claims it'll have to pay Frank's GMC for doing the work, because Volvo agreed to assume responsibility for the warranty. So they've got 2 pretty big items. Franks argues that any damages incurred by GM are purely of its own making, because GM made the choice to dismantle its warranty support and sell off or transfer its parts. However, the argument is spurious, as GM would incur costs in complying with the injunction, whether it phased parts warranty out and had to reconstitute them, or whether GM itself continued to maintain them. That's your argument, is these are the items we're going to be out. And this court says, we've held previously that absent circumstances where there's no risk of monetary loss to the defendant, then you got to require a bond. And what you guys need to know from a practical standpoint here is this gives you another argument as to whether, assuming or not assuming that the injunction is being granted, this, as you can see in the case, it bolsters the argument on immediate irreparable injury to say you need a big bond, because, and again, the court's going to balance these harms under the next part, under the latter parts of the test as well. But it helps to support the notion that there is real harm that's happening here, even to the party against whom the injunction is granted. And the bigger the bond, the harder it is to obtain. You might have to go pledge assets, or just simply pay a premium to get the bond. But again, the higher the bond, the higher the premium, the higher the bond. And depending on the nature of it, the court, the bonding company may ask you to pledge additional assets and the like. It can get very difficult depending on the size of the bond. Cases will settle over the whole notion of what that bond is. The problem is, as we're going to go through Rule 65C, this bond requirement is not consistently applied, But I think in a lot of cases, and we're going to see that this week, in a lot of cases, it's not consistently applied because the argument isn't advanced. You guys, the advocates in opposing injunctive relief, oftentimes focus on winning or losing just the round on injunctive relief and forget that there's another significant part here in opposing it and in creating the case as to what evidence you need in order to ask for a much larger bond in an effort to deter the plaintiff from moving forward. And I think that's the case here that's sort of lost at the trial court level, is there really was no requirement to make Frank post what I think would have been a bond of substantial size in order to make sure that if GM suffers as a result of this injunction, and the injunction is later determined, as it was here, to be improvidently granted, then there is an avenue for recourse for the damages you would have suffered as a result of that bond being wrongfully issued. You guys got questions on this case? I think it's a good case. It starts us out with the whole idea about, and at least in this is a pretty clear rule, but this is going to slide depending on what jurisdiction we're in. As long as there's no risk of a monetary loss to the defendant, no risk, then the failure to have them post a bond in getting the injunction is not error. But if there's a risk of monetary loss, there should be a bond. The rule requires the being of the bond. The problem we're going to see as we go forward is the amount of the bond, as it says even here under B. Although the amount of the bond is left to the discretion of the court, the posting requirement is much less discretionary. So you have to, as a general matter, you have to post it, but in a lot of cases, it's more of a token than a real resource for the party that against whom the injunction is granted. So look at that, think about that. I want to just leave you with some thoughts on this Aoud case so that we can have a concrete discussion next time. Because I think, obviously, if you read the case carefully, there's a lot of important things going on in it. But the biggest problem, and it starts early on, as I think in this case, is that your complaint, and that's the way I'm going to look at it, your complaint had documents on it that your client gave you that turned out to be fraudulent. And the rest of it just turns to garbage pretty quickly from there. So I'm wondering, A, what you do with the client like this, and how do you avoid getting caught in a trap like that? Because I'm sure the lawyers, I would expect, I hope, I pray, the lawyers weren't aware of it, but nonetheless, it obviously reflects poorly on the lawyers as well, which means poorly on you. So I'm wondering, as you look at this case and think about it, how you make sure that you're not caught in something like that, because you don't look very good. I also think it's interesting that this is Judge Selya, and obviously he writes so that you can use a dictionary when you read his decision. But he's fun, a little jerky at times, as you can see. But we can talk about that next time as well. But there's a lot going on in this case, a lot, and I want to talk about it in some detail as you look at it, because at least in part, it's not just the ethical issues that are problematic here, but there's issues about an evidentiary hearing, there's issues about the findings of fact and conclusions. There's a lot of screw-ups here, and I'm wondering how we can make sure that this doesn't happen to our clients or us specifically down the road. So I want to talk about that next time when we meet. So thank you.